Legal News Deep Dive Report from today. Today, Topic 1. Federal Court Scrutiny of EPA Pesticide Data and Regulatory Integrity. The first major legal development today centers on a federal judge's criticism of the data the federal government used to justify certain pesticide findings. The court is examining whether the agency relied on incomplete or methodologically flawed studies when assessing environmental and public health risks. This dispute highlights the tension between scientific uncertainty and the legal requirement that agencies base decisions on substantial evidence. Environmental groups argue that weak data can lead to under-regulation and long-term harm to ecosystems and farm workers. Industry groups, by contrast, warn that constantly revisiting scientific assumptions can create regulatory whiplash and economic instability. The case is also a test of how far courts will go in second-guessing technical judgments traditionally left to expert agencies. A key legal question is how courts should apply standards of review when the underlying science is contested. Historically, judges have given agencies deference when they act within their expertise, but recent trends show more willingness to interrogate the quality of the evidence. This shift may reflect broader skepticism about federal power and a desire to rein in what some see as overreach. At the same time, environmental advocates see judicial scrutiny as a necessary check when agencies appear to favor industry interests. The outcome could influence how agencies document and explain their reliance on scientific models and risk assessments. It may also encourage more transparent peer review processes and public comment on technical assumptions. Whatever the ruling, it will likely be cited in future challenges to environmental and health regulations. The case also intersects with broader debates about climate, agriculture, and food safety. Pesticide regulation sits at the crossroads of these issues, affecting biodiversity, water quality, and human exposure through food chains. Farmers are watching closely because changes in approved products can alter planting decisions and costs. Public health advocates emphasize that vulnerable communities, including rural and low-income populations, often bear disproportionate exposure risks. The court's handling of expert testimony and agency records will shape how future litigants frame scientific disputes. In the long run, this litigation may push agencies to invest more in robust, independent data collection. It also underscores how legal standards can either reinforce or undermine public trust in regulatory science. Subtopic 1.1. Standards of judicial review for scientific agency decisions. Courts reviewing scientific agency decisions typically apply deferential standards, but today's case shows that deference has limits. Judges are probing whether the agency genuinely engaged with contrary evidence or simply cherry-picked favorable studies. This scrutiny forces agencies to build more detailed administrative records that explain why certain data were accepted or rejected. Litigants now routinely bring their own experts to challenge agency methodologies, turning courtrooms into battlegrounds over statistical models and risk thresholds. As a result, judges must balance respect for expertise with their duty to ensure decisions are not arbitrary or capricious. The evolving case law may encourage agencies to adopt clearer guidelines for evaluating scientific uncertainty. Over time, this could reshape how science and law interact in regulatory disputes. Subtopic 1.2. Impact on environmental justice and vulnerable communities. Environmental justice advocates see this pesticide litigation as directly tied to the protection of vulnerable communities. Many of the affected populations live near agricultural fields or processing facilities where exposure risks are highest. When agencies rely on weak or incomplete data, these communities may be left without adequate safeguards. Legal challenges push agencies to consider cumulative impacts and long-term health outcomes, not just short-term averages. Courts are increasingly receptive to arguments that regulatory decisions must account for disproportionate burdens. This trend could lead to more detailed environmental justice analyses in future rulemakings. Ultimately, the case underscores how technical disputes over data can have very human consequences. Subtopic 1.3. Industry reliance interests and regulatory stability. Industry groups argue that constant legal challenges to scientific determinations undermine regulatory stability. Companies invest heavily in products and infrastructure based on existing approvals, and sudden changes can be costly. In today's dispute, industry lawyers emphasize reliance interests, claiming that revisiting pesticide findings years later creates uncertainty. Courts must weigh these economic concerns against the need to correct flawed or outdated science. Some judges may look for middle ground remedies, such as phase transitions or interim measures. This balancing act will influence how aggressively agencies feel they can revise prior determinations. The outcome may set expectations for how often and how quickly scientific standards can be updated. Subtopic 1.4. Transparency and public participation in scientific rulemaking. The litigation also highlights demands for greater transparency in how agencies handle scientific evidence. Advocacy groups argue that key datasets and models should be publicly accessible for independent review. Courts may respond by insisting that agencies better document their reasoning and respond to significant public comments. This could lead to more robust notice and comment processes, with extended timelines for technical feedback. Increased transparency might improve public trust, but also lengthen the rulemaking process. Today's case shows that litigants are willing to challenge not just outcomes, but the procedural openness of scientific decisions. Over time, this pressure may reshape the culture of regulatory science. Subtopic 1.5. Precedent for future climate and chemical regulation. Whatever the final ruling, today's pesticide case will likely be cited in future climate and chemical regulation disputes. Lawyers will look to the court's reasoning on data quality, uncertainty, and deference as a roadmap. If the court demands more rigorous evidence, agencies may need to invest in new studies before regulating emerging risks. Conversely, if the court upholds the agency's approach, it may signal that existing standards are sufficient. This precedent will matter for issues like greenhouse gas metrics, microplastics, and endocrine disruptors. The case thus sits at the front edge of how law will handle increasingly complex environmental science. Its influence will extend well beyond the specific pesticide at issue. Subtopic 1.6. Role of expert witnesses and Daubert-style challenges. Expert witnesses are central in today's litigation, with both sides presenting competing scientific narratives. Courts often use Daubert-style standards to assess whether expert testimony is reliable and relevant. This means judges must evaluate methodologies, error rates, and peer review status, even if they lack technical backgrounds. The process can elevate high-quality science, but also risk excluding novel or emerging research. Lawyers strategically frame expert testimony to align with legal standards rather than purely scientific debates. The outcome of these evidentiary battles can shape the entire trajectory of a case. As scientific issues grow more complex, the role of experts in legal proceedings will only become more pivotal. Subtopic 1.7. International implications for pesticide and trade policy. Pesticide regulation is not just a domestic issue. It affects international trade and treaty obligations. Trading partners may challenge regulatory changes as disguised trade barriers if they diverge sharply from global norms. Today's case could influence how the country positions itself in international negotiations over agricultural standards. If courts demand stronger evidence for restrictions, agencies may align more closely with global scientific bodies. Conversely, a more flexible approach could allow faster responses to emerging risks but create friction with exporters and importers. Legal outcomes in domestic courts can thus ripple through trade agreements and global supply chains. This interconnectedness makes today's litigation relevant far beyond national borders. Topic 2. Fourth Circuit upholds Virginia policy barring tax dollars for pastoral degrees. Another significant development today is a ruling from the Fourth Circuit upholding Virginia's policy that bars public funding for degrees in pastoral or devotional theology. The court concluded that the state's decision to exclude explicitly religious training from taxpayer-funded programs does not violate constitutional protections. This ruling revisits long-standing tensions between free exercise rights and the Establishment Clause. Religious institutions argued that the exclusion discriminated against faith-based education. The court, however, emphasized the state's interest in maintaining a secular funding framework. This decision will likely be cited in future disputes over public money flowing to religious schools and programs. The ruling sits within a broader national conversation about school vouchers, scholarships, and religious liberty. Recent Supreme Court cases have sometimes favored religious claimants seeking equal access to public benefits. Today's decision shows that lower courts still see room for states to draw lines around explicitly devotional training. The opinion carefully distinguishes between neutral aid programs and those that would directly subsidize religious instruction. This nuance matters for policymakers designing education funding schemes. It also signals to litigants that not every exclusion of religious uses will be struck down. The case thus adds another layer to an already complex body of law. The decision also has practical implications for students and institutions. Prospective theology students may need to rely more heavily on private scholarships or internal aid. Religious colleges might adjust their program structures to separate pastoral training from more general academic offerings. State officials, meanwhile, may review their funding criteria to ensure they align with the court's reasoning. Advocacy groups on both sides will likely use the ruling to support their broader narratives about religious freedom and church-state separation. Over time, this case may influence how other states craft their own policies. It underscores how funding rules can shape the landscape of religious education. Subtopic 2.1: Free exercise versus establishment clause balancing. At the heart of the case is the delicate balance between free exercise rights and the establishment clause. Religious plaintiffs argued that excluding pastoral degrees from funding penalizes their faith-based choices. The court responded that the state is not targeting religion but declining to sponsor religious instruction. This distinction reflects a long tradition of keeping government from directly supporting clergy training. The opinion suggests that neutrality does not always require equal funding for all religious uses. Instead, states may maintain secular boundaries so long as they do not single out particular faiths. This balancing framework will guide future litigation over religious access to public benefits. Subtopic 2.2: Comparison with recent Supreme Court voucher and funding cases. Today's ruling must be read alongside recent Supreme Court decisions that expanded religious access to public benefits. Those cases often involved neutral programs where religious schools were excluded solely because of their religious status. The Fourth Circuit distinguished the Virginia policy as focusing on the use of funds for pastoral training, not the identity of the institution. This status-use distinction has become a key battleground in church-state law. The court's approach suggests that some use-based exclusions may still be permissible. Litigants will likely test how far this reasoning can extend in future cases. The tension between these lines of precedent will shape the next wave of religious funding disputes. Subtopic 2.3: Implications for state scholarship and grant programs. State scholarship and grant programs across the country may look to today's decision for guidance. Many already include restrictions on funding for devotional or ministerial training. The Fourth Circuit's reasoning provides a roadmap for drafting and defending such provisions. Policymakers may refine statutory language to emphasize secular educational goals. Religious institutions, in turn, may adjust program descriptions to fit within permissible categories. The ruling thus has a practical regulatory impact beyond the immediate parties. It illustrates how appellate decisions can quietly reshape the architecture of public education funding. Subtopic 2.4: Effects on religious institutions and academic freedom. Religious institutions worry that funding exclusions could indirectly pressure them to alter curricula. If students cannot use public aid for certain programs, enrollment patterns may shift. Some schools might separate pastoral tracks from broader religious studies to preserve access to funding. Others may double down on their devotional mission and rely more on private support. The court's decision acknowledges these concerns but concludes that the state's secular funding limits are constitutionally permissible. Academic freedom remains intact, but financial incentives may influence institutional choices. This dynamic shows how law can shape educational ecosystems without directly regulating content. Subtopic 2.5: Student choice and equal access concerns. From the student perspective, the ruling raises questions about equal access to educational opportunities. Students pursuing secular degrees can tap into public aid, while those seeking pastoral training may be excluded. The court frames this as a consequence of the state's secular funding mission rather than discrimination. Critics argue that this effectively penalizes religious vocations. Supporters respond that taxpayers should not be compelled to fund clergy training. This debate reflects deeper disagreements about the role of religion in public life. Today's decision does not resolve those disagreements, but channels them into specific funding rules. Subtopic 2.6: Potential legislative responses at the state level. State legislatures may respond to the ruling by revisiting their own funding statutes. Some may tighten restrictions to mirror Virginia's approach, seeking to avoid litigation. Others might expand eligibility to include more religious programs, betting that courts will uphold broader access. Advocacy groups will lobby for changes that align with their constitutional interpretations. The decision thus becomes a political as well as legal touchstone. Over time, a patchwork of state approaches may emerge, inviting further judicial review. This iterative process shows how court decisions and legislative choices interact in shaping church-state boundaries. Subtopic 2.7. Long-term trajectory of church-state funding jurisprudence. Today's case is one step in a long trajectory of church-state funding jurisprudence. Courts have moved from strict separation toward more accommodation in some contexts. Yet, this ruling shows that limits on direct funding of religious instruction remain viable. The status-use distinction will likely continue to be contested in higher courts. Future cases may refine or narrow the space for state discretion. For now, the decision underscores that religious liberty claims do not automatically override secular funding principles. The evolving doctrine will remain a central feature of constitutional litigation for years to come. Topic 3. Federal workers criticize USDA Secretary's religious remarks at work. In another legal-adjacent development, federal workers have sharply criticized the Agriculture Secretary for publicly touting Jesus in a workplace context. While no final court ruling has been issued, the controversy raises serious questions about the boundaries of religious expression by high-level officials. Employees and advocacy groups argue that such remarks can create a coercive environment, especially for workers who do not share the same faith. The situation implicates both constitutional principles and internal ethics rules governing federal workplaces. It also highlights the tension between personal religious identity and the obligation to serve a religiously diverse public. How agencies respond to such incidents can shape workplace culture and potential legal exposure. The legal framework here involves both the Establishment Clause and federal employment law. Government officials must avoid actions that appear to endorse a particular religion on behalf of the state. At the same time, they retain some personal free speech and free exercise rights. The challenge is determining when a statement crosses from personal expression into official endorsement. Employees may file complaints alleging a hostile work environment or religious favoritism. Internal investigations could lead to policy clarifications or disciplinary measures. The controversy thus serves as a case study in managing religion in public institutions. This episode also resonates with broader cultural debates about religion in public life. Some see the Secretary's remarks as harmless expressions of faith, while others view them as exclusionary. The reaction from employees suggests that context matters greatly. What might be acceptable in a private setting can feel coercive in a hierarchical workplace. Legal standards often focus on how a reasonable observer would perceive the conduct. Agencies may respond by issuing clearer guidance on religious speech in official communications. Over time, such controversies can lead to more detailed training for managers and staff. The goal is to protect both religious freedom and workplace neutrality. Subtopic 3.1. Establishment Clause limits on official religious expression. The Establishment Clause prohibits government from endorsing or promoting a particular religion. When a cabinet-level official invokes specific religious language in an official setting, courts may view it as state endorsement. The key question is whether a reasonable observer would see the remarks as government speech rather than private expression. In hierarchical workplaces, employees may feel pressure to conform or remain silent. This perceived coercion can support claims of constitutional violation. Agencies, therefore, must be cautious about how leaders express personal beliefs in official contexts. Today's controversy underscores how sensitive this line can be. Subtopic 3.2. Hostile work environment and religious discrimination claims. Employees who feel marginalized by religious remarks may pursue hostile work environment claims. To succeed, they must show that the conduct was severe or pervasive enough to alter the conditions of employment. Isolated comments may not meet this threshold, but repeated or institutionalized religious messaging could. Workers might also allege that promotions or assignments are influenced by religious alignment. Agencies must investigate such complaints promptly and fairly. Failure to act can expose them to liability under federal anti-discrimination laws. The current controversy may prompt agencies to review their complaint procedures and training. Subtopic 3.3. Free exercise rights of public officials. Public officials do not surrender their free exercise rights when they take office. They may attend religious services, speak about their faith in personal settings, and participate in religious communities. The legal challenge is ensuring that these activities do not blur into official government endorsement. Courts often look at context, audience, and whether government resources are used. Officials can mitigate risk by clearly distinguishing personal remarks from official statements. Today's dispute illustrates how difficult that distinction can be in practice. It may lead to more explicit guidelines for high-level officials. Subtopic 3.4. Internal ethics rules and agency policies. Beyond constitutional law, agencies have internal ethics rules governing workplace conduct. These policies often address religious expression, political activity, and other sensitive topics. Violations can result in disciplinary action even if they do not rise to the level of constitutional violations. The current controversy may trigger a review of these policies at the Agriculture Department and beyond. Agencies might clarify what is appropriate in speeches, emails, and official events. Clearer rules can help leaders avoid missteps and give employees confidence in workplace neutrality. This internal governance layer is a crucial part of managing legal risk. Subtopic 3.5. Impact on employee morale and diversity initiatives. Religious controversies can significantly affect employee morale and diversity efforts. Workers who feel excluded or pressured may disengage or leave the agency. Diversity and inclusion programs aim to create environments where all beliefs, including non-belief, are respected. When leadership appears to favor one faith, those efforts can be undermined. The current situation may prompt renewed focus on religious diversity training. Agencies may also solicit feedback from employee resource groups. Over time, these responses can either repair trust or deepen divisions, depending on how they are handled. Subtopic 3.6. Public perception and political ramifications. The controversy also has public and political dimensions. Supporters of the secretary may frame criticism as hostility to religion, while opponents may see it as a clear breach of church-state separation. Media coverage can amplify these narratives and influence public opinion. Lawmakers might call for hearings or investigations, adding a legislative layer to the dispute. The agency's response will be scrutinized for signs of favoritism or overcorrection. This political context can complicate legal decision-making. Ultimately, the episode shows how legal, cultural, and political factors intertwine in public sector governance. Subtopic 3.7. Long-term guidance on religion in federal workplaces. In the long term, this controversy may lead to more detailed government-wide guidance on religion in the workplace. Existing policies may be updated to address social media, virtual meetings, and other modern contexts. Training materials could include case studies illustrating permissible and impermissible conduct. Agencies might also develop clearer channels for employees to raise concerns without fear of retaliation. These steps can help balance religious freedom with the need for a neutral, inclusive environment. The episode thus becomes a catalyst for refining best practices. Over time, such guidance can reduce the likelihood of similar disputes. Topic 4. Legal planning for America 250 celebrations and federal construction in Washington, D.C. Today's news also highlights legal and logistical planning for large-scale construction and renovation projects in Washington, D.C., ahead of the America 250 celebrations. Proposals include significant changes to iconic sites, raising questions about historic preservation, security, and public access. Legal frameworks governing federal property, environmental review, and procurement all come into play. Stakeholders range from preservationists to security agencies and local residents. The scale of the proposed projects makes them a focal point for debates about national identity and symbolism. Courts may eventually be asked to resolve disputes over approvals and compliance. The legal process for such projects typically involves multiple layers of review. Environmental impact assessments, historic preservation consultations, and public comment periods are standard. Agencies must coordinate with local authorities and sometimes international bodies if treaties are implicated. Disagreements can lead to litigation alleging inadequate review or failure to consider alternatives. Today's reporting suggests that some groups are already preparing legal strategies. The complexity of the process means that timelines can stretch, even under political pressure to move quickly. This tension between urgency and thoroughness is a recurring theme in major federal projects. These projects also raise questions about protest rights and public use of space. Changes to security perimeters, access routes, and public plazas can affect where and how people can assemble. Civil liberties groups will watch closely for any restrictions that might infringe on First Amendment rights. Courts have long recognized the special status of public forums near government buildings. Balancing security concerns with free expression will be a central challenge. The legal outcomes will shape not only the physical landscape, but also the civic life of the Capitol. America 250 thus becomes a lens for broader constitutional debates. Subtopic 4.1. Historic Preservation and the National Historic Preservation Act. Major changes to iconic federal sites trigger obligations under the National Historic Preservation Act. Agencies must identify historic properties, assess effects, and consult with preservation stakeholders. Failure to follow these steps can lead to legal challenges and project delays. Preservation groups may argue that proposed alterations undermine the historical integrity of national symbols. Agencies, in turn, may emphasize modernization and security needs. Courts reviewing such disputes focus on whether procedures were followed and impacts reasonably considered. Today's planning efforts will likely be shaped by this legal backdrop. Subtopic 4.2. Environmental Review under NEPA. Large construction projects typically require environmental review under the National Environmental Policy Act. Agencies must prepare environmental assessments or impact statements, analyzing alternatives and mitigation measures. Litigants often challenge these documents as incomplete or biased. Courts can require additional analysis or even halt projects if NEPA is not properly followed. The America 250 projects will likely face scrutiny over issues like traffic, noise, and ecological impacts. Thorough documentation can reduce legal risk, but takes time and resources. This trade-off is central to the current planning debates. Subtopic 4.3. Federal Procurement and Contracting Disputes. With major construction comes major contracting, and that invites procurement disputes. Companies that lose bids may challenge awards as arbitrary or inconsistent with procurement rules. Such challenges can delay projects and increase costs. Agencies must carefully document their selection criteria and evaluation processes. Transparency and fairness are key to withstanding legal scrutiny. Today's reporting suggests that many firms are positioning themselves for lucrative contracts. The legal framework for procurement will shape who ultimately builds the new infrastructure. Subtopic 4.4. Security Considerations and Constitutional Rights. Security agencies argue that changes to federal sites are necessary to address evolving threats. Measures may include barriers, surveillance, and restricted access zones. Civil liberties advocates worry that such changes can chill free speech and assembly. Courts must balance legitimate security interests with constitutional protections. Precedent recognizes that government can impose reasonable time, place, and manner restrictions, but not content-based discrimination. The America 250 projects will test how far security rationales can go. Legal challenges may focus on whether restrictions are narrowly tailored and leave open alternative channels for expression. Subtopic 4.5. Local federal coordination and home rule issues. Washington, D.C. has a unique governance structure that complicates major federal projects. Local officials must coordinate with federal agencies that control key properties. Disagreements can arise over zoning, transportation, and public services. Residents may feel that decisions are made without adequate local input. Legal disputes can involve questions of home rule and federal supremacy. Today's planning efforts highlight the need for robust intergovernmental dialogue. How these relationships are managed will affect both legal risk and public perception. Subtopic 4.6. Public Participation and Transparency in Planning. Public participation is a legal and political necessity for projects of this scale. Agencies must provide opportunities for comment and respond to significant concerns. Transparency about plans, timelines, and impacts can build trust, but also invite organized opposition. Legal challenges often hinge on whether public input was meaningfully considered. Today's reporting suggests that advocacy groups are mobilizing to influence the process. The quality of engagement may determine whether disputes are resolved administratively or in court. Effective participation can improve project design and reduce litigation. Subtopic 4.7 Symbolism, National Identity, and Constitutional Narratives. Beyond technical law, these projects carry symbolic weight. Changes to national monuments and buildings can be seen as statements about identity and values. Legal disputes may invoke constitutional narratives about democracy, equality, and memory. Advocates will frame their arguments in terms of what the nation should commemorate and how. Courts typically focus on procedural and statutory issues, but the symbolic context is never far away. America 250 thus becomes a stage for competing visions of the country's past and future. The legal outcomes will help determine which visions are physically embedded in the Capitol. Topic 5. Self-driving cars and the struggle to update traffic laws. Today's legal coverage also focuses on the rapid expansion of self-driving cars and the struggle of traffic laws to keep pace. Autonomous vehicles challenge traditional assumptions about driver responsibility, licensing, and enforcement. When a self-driving car breaks a traffic law, it is not obvious who should receive the ticket. Companies, software developers, and human occupants all have potential roles. Legislatures and courts are experimenting with new frameworks to allocate liability. The stakes are high, as these decisions will shape the future of transportation and public safety. Existing traffic codes were written with human drivers in mind. They assume a person is behind the wheel, making real-time decisions. Autonomous systems, by contrast, rely on sensors, algorithms, and remote updates. This mismatch creates legal gray areas when accidents occur or rules are violated. Some jurisdictions have begun to define operators in ways that include companies or remote supervisors. Others still treat the human occupant as the default responsible party. Today's reporting highlights the patchwork nature of these approaches. Over time, more uniform standards may emerge, but for now, uncertainty reigns. Liability for accidents involving self-driving cars is another major legal frontier. Traditional tort law focuses on driver negligence, but autonomous systems shift attention to product design and software errors. Plaintiffs may sue manufacturers, developers, or fleet operators rather than individual drivers. Courts must grapple with complex technical evidence about how algorithms made decisions. Insurance markets are also adjusting to new risk profiles. The legal outcomes will influence how quickly and widely self-driving technology is adopted. They will also shape incentives for safety and transparency in system design. Subtopic 5.1. Defining the driver in autonomous vehicle statutes. One core legal question is how to define the driver when a vehicle operates itself. Some laws now specify that the entity controlling the automated driving system is the driver. This can shift responsibility from the human occupant to the manufacturer or operator. Other statutes still assume a human driver, creating ambiguity in enforcement. Police officers may not know whom to cite when a self-driving car runs a red light. Legislatures are experimenting with definitions that reflect technological realities. The choices they make will have far-reaching consequences for liability and regulation. Subtopic 5.2. Product liability and software defects. As vehicles become more automated, product liability law takes center stage. Plaintiffs may argue that accidents result from defective software, inadequate testing, or poor system design. Manufacturers will defend their processes and point to human misuse or unforeseeable conditions. Courts must evaluate expert testimony on complex technical issues. Standards for what counts as a defect in an algorithm are still emerging. Regulatory agencies may issue guidance or rules that influence these determinations. Today's reporting suggests that early cases are setting important precedents. Over time, a body of law specific to autonomous systems will develop. Subtopic 5.3. Data, privacy, and evidentiary issues. Self-driving cars generate vast amounts of data about their surroundings and operations. This data can be crucial evidence in accident investigations and lawsuits. Legal questions arise about who owns the data and who can access it. Privacy advocates worry about constant tracking of movements and behaviors. Courts may need to decide when law enforcement can obtain vehicle data without a warrant. Discovery disputes in civil cases will focus on the scope and format of data production. The handling of this information will shape both accountability and privacy norms. Subtopic 5.4. regulatory sandboxes, and experimental frameworks. Some jurisdictions are using regulatory sandboxes to test self-driving technologies under controlled conditions. These frameworks allow limited deployments with special rules and oversight. The goal is to gather data and refine regulations before full-scale adoption. Legal questions include liability during testing, insurance requirements, and public disclosure. Sandboxes can accelerate innovation but also raise concerns about safety and transparency. Today's coverage notes that different regions are taking different approaches. The success or failure of these experiments will influence global regulatory strategies. Subtopic 5.5: Labor law and the displacement of human drivers. Autonomous vehicles also have implications for labor law and employment. As self-driving fleets expand, human drivers in trucking, taxis, and rideshare services may face displacement. Legal debates will focus on retraining, social safety nets, and collective bargaining. Some proposals call for new forms of worker support funded by companies that benefit from automation. Others emphasize the creation of new jobs in maintenance, monitoring, and data analysis. Labor law may need to adapt to changing employment structures. Today's reporting frames this as both an economic and legal challenge. Subtopic 5.6: Municipal authority and local traffic regulation. Cities play a key role in regulating traffic and public safety. They may impose local rules on where and how self-driving cars can operate. Conflicts can arise when local regulations clash with state or national frameworks. Companies may challenge municipal restrictions as preempted or discriminatory. Courts must interpret the scope of local authority in this new context. Today's coverage highlights early disputes over geofencing, speed limits, and curb space. The outcomes will shape the balance of power between local innovation and centralized control. Subtopic 5.7: Ethical frameworks and law of the newly possible. Beyond formal law, self-driving cars raise ethical questions about how machines should make life and death decisions. Scholars talk about the law of the newly possible to describe how legal systems respond to novel capabilities. Legislatures and courts must decide whether to encode ethical principles into regulations. Issues include how systems prioritize the safety of occupants versus pedestrians. Public input and philosophical debate will influence these choices. Today's reporting suggests that legal frameworks are still catching up to ethical concerns. The evolution of these norms will shape public acceptance of autonomous technology. Topic 6: Trump-targeted law firms seek to extend win streak against executive orders. Legal news today also covers law firms that have been repeatedly targeted by former President Trump and his allies, now seeking to extend a win streak in appellate courts. They argue that certain executive orders attacking their work on security clearances and investigations improperly interfered with the legal system. The case raises questions about separation of powers and the independence of lawyers representing unpopular clients. Courts must decide whether the executive branch overstepped by using security tools to punish legal advocacy. The outcome will affect how future administrations interact with lawyers involved in politically sensitive cases. It also speaks to the resilience of legal institutions under political pressure. The firms contend that the executive orders were not genuinely about national security, but about retaliation. They point to timing, public statements, and the narrow targeting of specific entities. The government, in turn, defends the orders as legitimate exercises of executive authority. Appellate judges will scrutinize the record for evidence of improper motive. They will also consider the broader implications of allowing such orders to stand. If courts find overreach, they may set limits on how security clearance processes can be used. This would reinforce protections for legal advocacy in contentious cases. This litigation fits into a larger pattern of disputes over executive power. Recent years have seen numerous challenges to orders affecting immigration, national security, and administrative agencies. Courts have sometimes been willing to look behind official justifications to examine actual motives. Today's case tests whether that approach extends to actions targeting law firms. The decision will influence how future presidents craft and defend executive orders. It will also signal to lawyers whether they can represent controversial clients without fear of government retaliation. The stakes for the rule of law are significant. Subtopic 6.1: Separation of powers and limits on executive authority. At the core of the case is the separation of powers between the executive and the judiciary. Law firms argue that executive interference with their work undermines the court's ability to function independently. If security tools can be weaponized against lawyers, judicial processes may be distorted. Courts must decide whether the challenged orders intrude on their domain. Precedent recognizes that the executive has broad authority in national security, but not unlimited. Today's litigation will clarify where those boundaries lie. The outcome will shape future conflicts between branches. Subtopic 6.2: Retaliatory motive and pretext analysis. A key issue is whether the executive orders were motivated by legitimate security concerns or by retaliation. Courts sometimes engage in pretext analysis, comparing official explanations with evidence of actual intent. Public statements, internal communications, and patterns of targeting can all be relevant. If judges find that security justifications are pretextual, they may strike down the orders. This approach has been used in other contexts, such as immigration and voting rights. Applying it here would extend judicial scrutiny into the realm of legal advocacy. The case thus tests how far courts will go in policing executive motives. Subtopic 6.3: Security clearances as a legal and political tool. Security clearances are essential for many government and contractor roles. They are also highly discretionary, making them vulnerable to politicization. Using clearance processes to punish disfavored lawyers would raise serious legal concerns. Courts have traditionally been reluctant to second-guess clearance decisions, citing national security. Today's case may push them to reconsider that deference when constitutional rights are at stake. The outcome could lead to new safeguards against abuse. It may also prompt legislative proposals to increase transparency and oversight. Subtopic 6.4: Professional independence and legal ethics. Lawyers have ethical obligations to represent clients zealously within the bounds of the law. If government retaliation becomes a real risk, it could chill representation in politically sensitive cases. Bar associations and legal ethics bodies may weigh in on the importance of professional independence. Courts recognize that access to counsel is a cornerstone of the justice system. Today's litigation highlights how executive actions can indirectly threaten that access. A ruling in favor of the firms would reinforce protections for legal advocacy. Conversely, a ruling for the government could raise concerns about future chilling effects. Subtopic 6.5: First Amendment protections for legal advocacy. Legal advocacy often involves speech, petitioning, and association, all protected by the First Amendment. Law firms may argue that targeting them for their work violates these rights. Courts must decide how to apply First Amendment principles in the context of security-related executive orders. Precedent protects lawyers from retaliation for representing unpopular clients. The government will argue that its actions are content-neutral and driven by security needs. The balance struck here will influence future cases involving lawyers, journalists, and activists. Today's case thus sits at the intersection of national security and free expression. Subtopic 6.6: Implications for future administrations and bipartisan norms. Whatever the outcome, the decision will set a precedent for future administrations of both parties. If courts allow broad use of security tools against legal adversaries, the practice could become normalized. That would erode bipartisan norms about respecting the independence of the bar. A ruling limiting such actions would reinforce those norms and deter future abuses. Political actors on all sides have an interest in clear, stable rules. Today's litigation is therefore not just about one administration, but about the long-term health of democratic institutions. The case will be closely watched by legal and political observers. Subtopic 6.7: International perceptions of rule of law. Internationally, the treatment of lawyers is seen as a key indicator of rule of law. Retaliation against legal advocates can damage a country's reputation and influence. Human rights organizations may cite today's case in their assessments. Courts are aware that their decisions can have global resonance. A strong affirmation of legal independence would bolster claims of robust constitutional protections. Conversely, perceived tolerance of retaliation could invite criticism. The case thus has implications beyond domestic politics, affecting diplomatic and soft power dynamics. Topic 7: Supreme Court sidesteps principle on election eve changes to voting rules. Today's legal news also notes that the Supreme Court has again sidestepped its own often invoked principle against making election eve changes to voting rules. Over the past 2 decades, the court has warned that late judicial interventions can confuse voters and administrators. Yet in recent cases, it has issued decisions close to elections that effectively alter the legal landscape. Critics argue that this inconsistency undermines the so-called Purcell principle. Supporters say that the court must sometimes act quickly to correct serious legal errors. The tension reflects deeper disagreements about judicial restraint in election law. The Purcell principle is not a formal rule, but a prudential guideline. It suggests that courts should avoid changing election rules shortly before voting begins. The idea is to preserve stability and public confidence. However, the court has applied the principle unevenly, sometimes intervening late when it sees urgent constitutional issues. Today's reporting highlights another instance where the court's timing raises questions. Litigants and lower courts struggle to predict when the principle will be invoked. This uncertainty complicates election planning and litigation strategies. The stakes are high because late changes can affect turnout, ballot access, and perceptions of legitimacy. Voting rights advocates worry that inconsistent application of the principle can disadvantage certain groups. States and election officials seek clear guidance to avoid last-minute chaos. The court's approach also influences how aggressively lower courts address election disputes. Today's developments suggest that the Purcell principle remains more of a flexible consideration than a binding constraint. That flexibility can be both a strength and a source of controversy. The debate will continue as new election cases arise. Subtopic 7.1. Origins and Evolution of the Purcell Principle. The Purcell Principle traces back to a 2006 Supreme Court case emphasizing caution about late election changes. Over time, it has been cited in numerous emergency applications and shadow docket decisions. The principle reflects concerns about voter confusion and administrative burden. However, it has never been codified as a strict rule. Courts have considerable discretion in deciding when it applies. Today's case adds another data point in its evolving interpretation. Scholars debate whether the principle has become too malleable to provide real guidance. Subtopic 7.2. Shadow docket and emergency election rulings. Many election eve decisions occur on the court's so-called shadow docket, without full briefing or oral argument. Critics argue that this process lacks transparency and reasoned explanation. Supporters say it is necessary to handle urgent matters quickly. Today's reporting notes that the court's latest move again came through emergency procedures. This raises questions about how much weight to give such decisions as precedent. The use of the shadow docket in election cases has become a major topic in legal scholarship. It affects perceptions of legitimacy and fairness in election law. Subtopic 7.3. Impact on state election administrators. State and local election officials must implement whatever rules are in place when voting begins. Late judicial changes can force them to revise procedures, reprint materials, or retrain staff. This can strain resources and increase the risk of errors. Officials often plead for stability and clear timelines. The court's uneven application of the Purcell principle makes planning more difficult. Today's developments may prompt renewed calls for earlier resolution of election disputes. Administrative realities thus intersect with constitutional doctrine. Subtopic 7.4. Voting rights and disparate impact concerns. Voting rights advocates worry that late changes can disproportionately affect marginalized communities. For example, changes to mail and ballot rules or polling locations can hit certain voters harder. Inconsistent application of the Purcell principle may exacerbate these disparities. Advocates argue that courts should prioritize protecting access to the ballot. The court, however, may weigh competing concerns about state authority and legal stability. Today's case illustrates how these tensions play out in real time. The impact on turnout and representation can be significant. Subtopic 7.5. Lower court behavior and strategic litigation. Lower courts look to the Supreme Court for guidance on when to intervene in election disputes. Uncertainty about the Purcell principle can lead to cautious or aggressive approaches. Litigants may time their lawsuits strategically, hoping to force late decisions. The court's recent behavior may encourage or discourage such tactics. Today's developments will be closely studied by election lawyers. The interplay between timing, strategy, and doctrine is a defining feature of modern election litigation. Purcell principle may exacerbate these disparities. Advocates argue that courts should prioritize protecting access to the ballot. The court, however, may weigh competing concerns about state authority and legal stability. Today's case illustrates how these tensions play out in real time. The impact on turnout and representation can be significant, not just about one administration, but about the long-term health of democratic institutions. The case will be closely watched by legal and political observers. Subtopic 7.6. Public confidence and perceptions of partisanship. Public confidence in elections depends partly on perceptions of judicial neutrality. When the court intervenes late, especially along ideological lines, critics see partisanship. The Purcell principle was supposed to reduce such concerns by limiting last-minute changes. Its inconsistent application can have the opposite effect. Today's case may fuel narratives about judicial bias. The court must balance its duty to enforce the Constitution with the need to maintain legitimacy. This balance is particularly delicate in election cases. Subtopic 7.7. Prospects for clearer standards in election timing. Looking ahead, some scholars and advocates call for clearer standards on when courts should intervene before elections. Proposals include firm deadlines for major changes or presumptions against late rulings. The court has so far resisted turning the Purcell principle into a rigid rule. Today's developments suggest that flexibility remains the norm. However, continued controversy may eventually prompt more explicit guidance. For now, election law remains a field where timing is as important as substance. Topic 8. Harvey Weinstein retrial halted by health scare and procedural implications. In high-profile criminal news, jury deliberations in Harvey Weinstein's rape retrial were halted due to reports of chest pains and hospitalization. While primarily a factual development, it carries procedural and legal implications. Courts must balance the defendant's health needs with the public interest in timely justice. Delays can affect witness availability, juror memory, and public perception. High-profile cases also raise concerns about media influence and fairness. Today's events highlight how unexpected health issues can complicate complex trials. When a defendant experiences a medical emergency during trial, judges must assess competency and ability to participate. Criminal defendants have a right to be present and to assist in their defense. If health problems are serious, courts may order evaluations or pauses in proceedings. Prolonged delays can raise speedy trial concerns. Prosecutors and defense counsel may disagree about how to proceed. In a case as prominent as Weinstein's, every decision is scrutinized. The legal system must navigate these challenges while preserving due process. The retrial itself reflects broader debates about sexual assault prosecutions and #MeToo era accountability. Procedural setbacks can be frustrating for survivors and advocates seeking closure. Defense teams may argue that delays prejudice their client or reflect overzealous prosecution. Courts must maintain neutrality amid intense public attention. Today's health-related pause adds another layer of complexity. It underscores how human factors intersect with legal processes. The outcome will influence perceptions of justice in this closely watched case. Subtopic 8.1. Competency and the right to be present. Defendants have a constitutional right to be present at critical stages of their trial. Health issues can impair their ability to understand proceedings or consult with counsel. Courts may order medical evaluations to determine competency. If a defendant is temporarily incapacitated, proceedings may be paused. Long-term incapacity raises harder questions about dismissal or alternative arrangements. Today's events may trigger such evaluations in Weinstein's case. The legal standards aim to protect both fairness and the integrity of the process. Subtopic 8.2. Speedy trial rights and delays. The right to a speedy trial protects defendants from prolonged uncertainty and potential prejudice. Health-related delays complicate the analysis because they may be unavoidable. Courts consider factors such as the length of delay, reasons, and prejudice to the defendant. High-profile cases often involve complex evidence and multiple witnesses, making scheduling difficult. Today's pause will factor into any future speedy trial arguments. Judges must balance compassion with legal obligations. The case illustrates how constitutional rights interact with real-world contingencies. Subtopic 8.3: Jury Management and Potential Mistrial Risks. Extended interruptions during deliberations can affect juror focus and cohesion. Judges may need to remind jurors not to discuss the case or consume media during breaks. In extreme cases, delays can lead to mistrials if jurors are lost or compromised. High-profile cases increase the risk of outside influence. Today's health-related halt will require careful jury instructions. Courts must protect the integrity of deliberations while accommodating necessary pauses. The management of juries is a critical but often underappreciated aspect of trial law. Subtopic 8.4: Media Coverage and Fair Trial Concerns. Media attention in celebrity cases can shape public narratives and potentially influence jurors. Courts may issue gag orders or limit cameras to protect fairness. Health emergencies can generate additional coverage and speculation. Lawyers must navigate public relations while focusing on legal strategy. Today's events will likely dominate headlines, adding pressure on all participants. Judges may remind jurors to avoid media and rely solely on evidence. The tension between transparency and fairness is acute in such cases. Subtopic 8.5: Victim and Survivor Perspectives on Delays. For alleged victims, delays can be emotionally taxing and re-traumatizing. They may feel that justice is being postponed or denied. Advocates emphasize the need for timely resolution while respecting due process. Courts sometimes provide support services or liaisons to keep victims informed. Today's pause in Weinstein's retrial will affect expectations and emotions. The legal system must acknowledge these human impacts even as it follows procedural rules. Balancing these interests is a core challenge in sexual assault prosecutions. Subtopic 8.6: Defense Strategy and Health-Related Arguments. Defense teams may incorporate health issues into their broader strategy. They might argue that the defendant's condition limits their ability to endure trial or incarceration. Courts must evaluate medical evidence carefully. Health concerns can influence sentencing as well as trial scheduling. Today's events may lead to motions or requests from Weinstein's lawyers. The line between legitimate health considerations and strategic delay is sometimes contested. Judges must exercise discretion with both skepticism and empathy. Subtopic 8.7: Broader implications. Implications for high-profile criminal justice. The Weinstein retrial is emblematic of broader shifts in how the justice system handles powerful defendants accused of sexual misconduct. Procedural twists, including health-related delays, feed into public debates about accountability. Some see any setback as evidence of a system that favors the powerful. Others emphasize the importance of rigorous due process for all. Today's events will be interpreted through these lenses. The case thus serves as a barometer for public trust in criminal justice. Its resolution will have symbolic as well as legal significance. Topic 9: ChatGPT-linked mass shootings and emerging developer liability concerns. Today's legal reporting also covers growing concerns about mass shootings allegedly linked to heavy use of chatbots like ChatGPT and what that means for developer liability. Victims and their families are exploring lawsuits arguing that chatbot use contributed to radicalization or planning. Courts must decide whether developers can be held responsible when their tools are implicated in real-world violence. Existing legal frameworks, including Section 230 and product liability doctrines, are being tested. The outcome will shape the responsibilities of AI companies in designing and monitoring their systems. It also raises profound questions about speech, causation, and foreseeability. Plaintiffs may argue that developers knew or should have known that their systems could be misused. They might point to internal documents, safety warnings, or prior incidents. Developers will respond that they cannot control how users interact with general-purpose tools. They will also invoke legal protections for interactive computer services. Courts must assess whether chatbot outputs are more like user speech, publisher content, or product features. This classification will influence the applicable legal standards. Today's cases are among the first to confront these issues in the context of violent crime. Causation is a central challenge in these lawsuits. Plaintiffs must show that chatbot interactions meaningfully contributed to the harm. Defendants will argue that human agency and other factors break the causal chain. Expert testimony may address how users were influenced by AI outputs. Courts will grapple with novel questions about psychological impact and technological mediation. The results will set precedents for future AI-related harm claims. They will also influence how companies design safeguards and content policies. The stakes extend beyond any single platform or incident. Subtopic 9.1. Section 230 and its limits in AI contexts. Section 230 has long shielded online platforms from liability for user-generated content. Its application to AI-generated outputs is contested. Developers may argue that chatbot responses are derived from user prompts and thus covered. Plaintiffs may counter that AI systems create new content and should be treated differently. Courts are beginning to parse these distinctions. Today's cases involving violent incidents will test how far Section 230 extends. The outcomes could prompt legislative revisions or clarifications. Subtopic 9.2. Product liability theories for AI systems. Some plaintiffs frame AI systems as products with design defects or inadequate warnings. Under product liability law, manufacturers can be held responsible for foreseeable harms. Applying these doctrines to software and algorithms is complex. Courts must decide what counts as a defect in an AI system. They may consider training data, safety filters, and monitoring practices. Today's lawsuits will help define the contours of AI product liability. The results will influence industry standards and risk management. Subtopic 9.3. Duty to monitor and content moderation obligations. Another issue is whether developers have a duty to monitor and intervene in harmful uses. Plaintiffs may argue that companies should detect patterns of dangerous behavior and act. Developers will point to privacy concerns, technical limits, and scale challenges. Courts must balance safety expectations with practical realities. Regulatory bodies may also weigh in with guidance or rules. Today's cases highlight the tension between user autonomy and platform responsibility. The resolution will shape future moderation practices. Subtopic 9.4. Free speech and prior restraint concerns. Efforts to hold AI developers liable for harmful outputs raise free speech questions. Companies may argue that imposing liability would chill innovation and lawful expression. Plaintiffs respond that safety measures can coexist with robust speech protections. Courts must avoid creating de facto prior restraints while addressing genuine risks. The line between permissible regulation and unconstitutional censorship is delicate. Today's litigation will contribute to this evolving jurisprudence. The stakes are high for both civil liberties and public safety. Subtopic 9.5. Foreseeability and risk assessment in AI deployment. Foreseeability is a key element in many liability frameworks. Plaintiffs will argue that misuse of AI for planning violence is foreseeable given prior incidents. Developers may counter that such uses are rare and difficult to predict. Courts will examine what companies knew and what steps they took to mitigate risks. Risk assessment processes, internal audits, and safety teams will come under scrutiny. Today's cases may encourage more robust pre-deployment evaluations. They also highlight the need for ongoing monitoring and adaptation. Subtopic 9.6. Regulatory responses and policy debates. Regulators are watching these developments closely. Some may propose new rules specifically addressing AI safety and accountability. Options include mandatory risk assessments, reporting obligations, or liability frameworks. Industry groups will lobby for flexible, innovation-friendly approaches. Civil society organizations will push for stronger protections against harm. Today's litigation will inform these policy debates. The interplay between courts and regulators will shape the future of AI governance. Subtopic 9.7. International Perspectives on AI Liability. Other countries are also grappling with AI-related harms and liability. The European Union, for example, is developing regulatory frameworks that may influence global norms. Courts may look to foreign approaches for inspiration or contrast. Companies operating globally must navigate multiple legal regimes. Today's cases in one jurisdiction can have ripple effects elsewhere. Comparative law will play a growing role in AI liability discussions. The emerging patchwork of rules will challenge both developers and users. Topic 10. Texas immigration arrest law likely to be blocked again. Finally, today's legal news reports that Texas's controversial immigration arrest law is likely to be blocked again. The law would give state authorities expanded power to arrest and remove individuals suspected of immigration violations. Critics argue that it conflicts with federal supremacy in immigration enforcement. Courts have previously halted similar measures, citing preemption and constitutional concerns. The latest developments suggest that federal courts remain skeptical. The outcome will affect not only Texas but other states considering similar laws. The law raises questions about the balance of power between state and federal governments. Immigration has traditionally been a federal domain, though states play supporting roles. Texas argues that federal enforcement is inadequate and that states must step in. Opponents warn that state-level immigration policing can lead to racial profiling and civil rights violations. Courts must interpret federal statutes and constitutional principles to resolve the conflict. Today's indications of another likely block reinforce prior precedents. They signal limits on how far states can go in this area. The law also has practical implications for communities and law enforcement. Local police may be drawn into immigration enforcement, affecting trust with immigrant communities. Fear of arrest can deter people from reporting crimes or cooperating with investigations. Civil rights groups are preparing challenges based on equal protection and due process. The federal government may also sue to assert its authority. Today's developments suggest that litigation will continue for some time. The case is a focal point in national debates over immigration policy. Subtopic 10.1. Federal Preemption and Immigration Authority. Federal preemption is central to the legal analysis of state immigration laws. When Congress occupies a field, states have limited room to legislate. Courts have struck down state measures that conflict with federal objectives. Texas's law will be evaluated against this backdrop. The state may argue that it complements federal enforcement rather than conflicts with it. Opponents will point to specific statutory schemes and enforcement priorities. Today's indications of a likely block suggest that preemption arguments remain strong. Subtopic 10.2. Supremacy Clause and State-Federal Conflicts. The Supremacy Clause establishes that federal law is the supreme law of the land. When state and federal laws conflict, federal law prevails. In immigration, this often means that federal enforcement priorities trump state initiatives. Texas's law tests how far states can go in parallel enforcement. Courts must decide whether the law creates an impermissible conflict. Today's developments suggest that judges see significant tension with federal policy. The case will clarify the boundaries of state authority. Subtopic 10.3. Civil Rights and Racial Profiling Concerns. Civil rights groups warn that state immigration laws can lead to racial profiling. Broad arrest powers may be used disproportionately against certain communities. Courts may consider evidence of discriminatory intent or impact. Equal protection claims could play a major role in challenges. Today's reporting notes that advocacy organizations are preparing such arguments. The law's implementation, if allowed, would be closely monitored. Civil rights concerns add another layer to the legal analysis. Subtopic 10.4. Local law enforcement and community trust. Local law enforcement agencies worry that immigration policing can erode community trust. If residents fear that any interaction with police could lead to immigration consequences, they may avoid reporting crimes. This undermines public safety and cooperation. Some local officials oppose state mandates that draw them into immigration enforcement. Courts may consider these practical impacts in assessing the law's reasonableness. Today's developments highlight the tension between state directives and local policing priorities. The outcome will affect law enforcement strategies on the ground. Subtopic 10.5 Federal Government Litigation and Enforcement Discretion. The federal government may challenge Texas's law as an intrusion on its enforcement discretion. Courts have recognized that the executive branch has leeway in setting immigration priorities. State laws that force different priorities can create conflicts. Today's indications of a likely block suggest that federal arguments are resonating. The case will clarify how much discretion the federal government has to resist state initiatives. It will also influence future negotiations between federal and state officials. Subtopic 10.6 Broader Political and Policy Implications. The Texas law is part of a broader political struggle over immigration policy. Supporters see it as a necessary response to perceived federal inaction. Opponents view it as punitive and counterproductive. Court decisions will shape the policy landscape, but not resolve underlying disagreements. Legislatures at both state and federal levels may respond with new proposals. Today's developments will be used by both sides to support their narratives. The law thus sits at the intersection of law, politics, and public opinion. Subtopic 10.7 Precedent for other states and future litigation. Other states are watching the Texas case closely. A strong ruling against the law may deter similar measures elsewhere. A more permissive ruling could encourage copycat legislation. Today's indications of another likely block suggest that courts remain wary. The case will contribute to a growing body of precedent on state immigration authority. Future litigants will cite it in challenges to new laws. The evolving jurisprudence will shape the national map of immigration enforcement. YouTube-style video description. Title: Deep legal news dive from today. Courts, AI liability, elections, immigration, and more. Description: Dive into a detailed, research-driven breakdown of today's biggest legal news stories from the United States and beyond. We cover 10 major topics, from federal courts questioning pesticide data and church-state funding battles, to self-driving car liability, election eve Supreme Court moves, AI-linked violence lawsuits, Texas's immigration arrest law, and more, plus focused subtopics that unpack the legal stakes in depth. You'll hear about constitutional clashes, separation of powers fights, criminal procedure twists, emerging AI liability theories, and how these cases could reshape environmental regulation, religious funding, workplace rules, election law, immigration enforcement, and civil rights. This video is for information and news discussion only. Nothing here is legal, medical, financial, or official advice. Do not rely on any part of this video for decisions about your life, your health, your money, or your legal situation. Always consult a qualified professional. News is news, not advice, and anecdotal stories are not guidance. If you like deep dives into real legal developments, subscribe and check back for daily reports. Tags: SEO friendly, comma separated. Legal news, court decisions, Supreme Court, election law, Purcell principle, environmental law, pesticide regulation, church-state separation, religious liberty, public funding for religion, workplace religion, federal employees, America 250.